Welcome to Washington Today on C-SPAN Radio for Tuesday, April 18th, 2023. Supreme Court hears a case asking the question, when must businesses accommodate the needs of religious employees? The lawsuit comes from a former mail carrier in Pennsylvania who was told he had to work Sundays in violation, he says, of his Christian beliefs in that Sabbath day of rest. Coming up, we hear some of today's Supreme Court oral argument and talk about the case with Time magazine reporter Sanya Mansoor. It is tax day, the deadline for most people to file federal tax returns or ask for an extension. House Republicans and Democrats offering different tax reform proposals. House Speaker Kevin McCarthy presenting his plan to other House Republicans on raising the national debt limit to avoid a first-ever default and coupling that with federal spending cuts. That's an approach already rejected by President Biden and Congressional Democrats. House votes on an override attempt of the president's veto of a bill that would reverse new regulations on what waterways in the United States are subject to the Clean Water Act. Homeland Security Secretary Alejandro Mayorkas talking about what will happen in just under a month when Title 42 expires. That's the public health emergency authority that's been used to keep migrants from crossing the Mexico border into the United States. As one Republican senator introduces a resolution expressing a no-confidence vote in Secretary Mayorkas because of his handling of the immigration issue. This from CNN, the Supreme Court seemed to side with a former mail carrier, an evangelical Christian, who says the U.S. Postal Service failed to accommodate his request to not work on Sundays. A lower court had ruled against the worker, Gerald Groff, holding that his request would cause an undue burden on the U.S. Postal Service and lead to low morale at the workplace when other employees had to pick up his shifts. But during oral arguments on Tuesday, there appeared to be a consensus, after almost 2 hours of oral argument, that the appeals court had been too quick to rule against Gerald Groff. There seemed to be, as Justice Elena Kagan put it, some level of kumbayaing between the justices on the bench at times. That from CNN. We spoke with Time magazine reporter Sanya Mansoor about the standard for employee religious practice accommodation that the Supreme Court has used in these cases and what changes are being proposed.
A lot of the legal experts that I had spoken with says the current standard for employers to deny requests for religious accommodation is actually very low and somewhat toothless even. So what you need to know about the standard is, the first time this was really enshrined in federal law is under Title VII of the 1964 Civil Rights Act, in which it required employers show that an employee's request for religious accommodations would create an undue hardship in order to deny it. So that's initially what was put forth. But that standard was then changed and essentially undercut by a later Supreme Court ruling, which came in 1997 in the case Trans World Airlines versus Hardison. And the issue is that the Supreme Court basically came out of that. Supreme Court came out of the Hardison case and said that they interpreted this undue hardship term to be more so of a minimal cost, a very minimal cost, as opposed to what legal experts say most people would understand undue hardship to mean, something more than just a minimal cost. So because of this new standard that was set forth in the 70s, it's become very easy for employers to routinely deny religious accommodations, not just in the case of, we're seeing the case with Groff in particular deals with Sabbath observance. There can be other scheduling conflicts, things like Friday prayer for Muslims like Jummah, but also in the case of religious attire, wearing a yarmulke or wearing a hijab, even having dreadlocks if you're Rastafarian. But the standard for denying these kinds of things has lowered significantly for employers. So what we would expect to see with the Supreme Court ruling is that given that many on the court, both left and right, are would actually want to strengthen, I think in this case, protections for religious employees here, we could very likely see a strengthening of that standard. Basically, it would be harder than for employers to deny requests for religious accommodations.
Is this a constitutional question or a statutory question? Is this a matter of fundamental right, or is Congress setting the law?
So that's a good question. I will say that part of the Postal Service's argument too, as I was speaking to legal experts, they told me that there's an idea that Congress obviously put forth the Civil Rights Act, and then the Supreme Court weighed in. The Postal Service also, argues that Hardison is precedent, right? And because it's precedent, it shouldn't be easily overturned. There's also an idea that, one of the legal experts I was speaking to told me that, Congress has the ability to revise its own statute in response to Supreme Court ruling. So, Congress has had time to amend the statute. They have not yet done that, and if they wanted to, they could. So that's part of actually the argument of the Postal Office, that Congress could take action here. But in the way that we're seeing it play out right now, the courts could very well kind of strengthen religious accommodations for employees.
Maybe not directly related to this case, but has the Supreme Court ever ruled on what constitutes a religion or a practice?
I'm actually not entirely sure, but I will say there is one other pretty relevant Supreme Court case over here that it was relatively high profile. The Supreme Court, was looking again at this Hardison standard when it sided with the Equal Employment Opportunity Commission against Abercrombie and Fitch. So that was that was back in 2015. Abercrombie had refused to hire a 17-year-old Muslim woman who wore a hijab because it violated the store's look policy. And the Supreme Court eventually, took the side of the EEOC. So that's one that comes to mind. Apologies, I don't have a better answer for that particular question, but I would just offer that piece of context.
Sanya Mansoor, Time Magazine reporter. Find her stories at time.com and on Twitter at Sanya_Mansoor. Thank you very much.
Thanks so much.
And now some of the oral argument in today's Supreme Court case, Groff v. DeJoy. Louis DeJoy is the Postmaster General, and the plaintiff, Gerald Groff. The attorney for Gerald Groff, Aaron Street, questioned by Justice Ketanji Brown Jackson.
Justice Kavanaugh asked you about the government's substantial costs test, and I thought I heard you say, that sounds pretty good to me, but the problem is in the application. So I guess I'm trying to understand, is there any daylight between the test that you are advocating for, significant difficulty and expense, and the government's test, substantial cost? They seem pretty synonymous to me. So can you help me figure out the difference?
Certainly, Your Honor. We know what significant difficulty and expense means because it's been applied under these other statutes, which employers are already applying every day. In New York and California are applying. I don't know what substantial cost means because those are just two words on a page. The only way to tell what that means is to look at how the government applied them and how Hardison applied them.
So do you have an example of, the government has written a brief, you've written a brief, there are two different standards in them. Can you give us an example of a case that would come out differently under the different tests?
Certainly, Your Honor. Paying $100 a week to somebody to attract them to take on a Sabbath shift, that would probably not be an undue hardship under our test, especially for a larger employer, but that's the holding of Hardison, and that would be an undue hardship under the government's test. Denying a single coworker's shift preference, the government says that that's an undue hardship on
because of substantial cost being the test?
Well, that's a question for the government, I guess, how substantial cost links up with its
All right, let me ask you another question then, just one more. With respect to the questions about the establishment clause and the shifting views as to what the Constitution permits, is there any impediment to Congress's acting now? I mean, setting aside the fact that there's been a change in terms of the court, presumably Congress knows that and could change the statute now, right?
Absolutely, Congress could change the statute now, and the question is just whether this court should place on Congress's shoulders the burden of this court's error in Hardison.
But well, that assumes that that's the reason why Congress picked this particular test. But I mean, isn't this a policy question at bottom for Congress? And I guess I'm a little worried about the history of people going to Congress and the many bills. Apparently, Hardison has been on Congress's radar screen for a very long time, and they've never changed it. And I guess I'm concerned that, a person could fail to get in Congress what they want with respect to changing the statutory standard and then just come to the court and say, you give it to us. Why shouldn't we wait for Congress? Now that the, law has shifted, as Justice Alito pointed out, why isn't this the opportunity for them to act?
We agree wholeheartedly that this is a policy question for Congress, but Congress answered that question in 1972 when it enacted the words undue hardship on the conduct of the employer's business.
So is that an impediment for Congress to revisit it today? Do they have a similar stare decisis scenario?
No, of course Congress could address it today. And the question before the court is, of course, under the stare decisis factors, when the reasoning has been eroded, when the government's not even defending the reasoning of the test, whether this court should go to the text and interpret it in a way according with plain meaning.
Thank you.
Supreme Court Justice Ketanji Brown Jackson questioning Aaron Street, attorney for Gerald Groff, in today's oral argument, the case Groff v. DeJoy. Arguing for the Postal Service, Elizabeth Prelogger, the U.S. Solicitor General, questioned here by Justice Samuel Alito.
Let me give you a hypothetical. Say Amazon has to offer a $16 an hour rate instead of $15 an hour rate to get a consistent volunteer to take a Saturday shift for a Jehovah's Witness or an Orthodox Jew. Is that an undue hardship?
So the line that we understand Hardison to have drawn is based on the idea that you would have to incur substantial overtime costs on a regular, ongoing basis. And I don't think that it depends entirely on the ultimate, at the end of the day, out-of-pocket costs for the employer, because I acknowledge in the Amazon example, even if it were a significant delta and it was much greater wages, Amazon could probably afford that. But instead, I think that this has to go to the nature of that type of accommodation.
What's the answer to my question? It's $1 an hour more, and it's Amazon.
Or
it's Walmart, or it's the old TWA, but it's regular. Is that an undue hardship? Yes or no? Can you answer that for me?
I'm not sure that it would be proper to characterize $1 an hour difference as premium overtime wages. I think there'd be an initial fact question about the different levels at which Amazon reimburses its employees.
Okay, so premium, really, General, could you please answer my question? Premium doesn't mean just anything above the regular wage. Is that what you're saying?
We're interpreting it the way the court focused on that in Hardison. There, I believe it was time and a half or maybe double time to fill those shifts, and the court characterized that as regular payment of overtime wages that crossed the line. But it's not just about the out-of-pocket.
I take that to mean that premium pay is not just anything more than the ordinary pay. It has to be substantially more than the ordinary pay, right?
I think that is consistent with the court's decision in Hardison, but I want to emphasize as well that the way that an accommodation ordinarily operates is to provide some kind of flexibility that allows the employee to complete his work requirements without having that conflict with his religious belief. And one of the reasons why I think the court drew this distinction with regular payment of overtime wages is that it's a different type of accommodation. It's exempting the employer on an ongoing permanent basis from doing that portion of his work. So I think it actually tracks a little bit with the kinds of questions that Justice Barrett was asking about what's the nature of a reasonable accommodation in the first place, although I recognize that's not the way that the court thought about the issue in Hardison.
Elizabeth Prelogger, U.S. Solicitor General, questioned by Supreme Court Justice Samuel Alito. C-SPAN covered the entire oral argument in this case, Groff v. DeJoy. It's still audio only from the court, and we have it archived at cspan.org, runs just short of 2 hours. From NBC News, key Senate Democrats are eyeing a hearing about Supreme Court ethics in the wake of revelations about Justice Clarence Thomas receiving previously undisclosed gifts and luxury travel from billionaire Republican donor Harlan Crow. Senator Dick Durbin, Democrat from Illinois, the Majority Whip and Judiciary Committee Chair, said the 20 years of gift travel on yachts and chartered planes was outrageous. He added that the failure to disclose Harlan Crow's real estate deals and reported purchase of Justice Thomas's mother's home was beyond anything I could imagine at the Supreme Court level. The article from NBC goes on, it's not clear when the hearing will take place or what the scope will be, but Senator Dick Durbin said he has a number of things in mind. Senator Durbin spoke on the Senate floor today.
And as the recent ProPublica series has revealed, some justices simply aren't telling the American people about the gifts and travel that they are accepting. Frankly, the excuses we've heard thus far from Justice Thomas are laughable. Claiming that a private luxury yacht in Indonesia from a major political donor was, quote, personal hospitality, close quote, that didn't need to be disclosed is an absurd conclusion. And it's insulting to the American people who expect justices to be held to the same standards as anyone else in government. That's why reform is essential. It is critical to our justice system and to our democracy that the American people have confidence that the judges, and especially the Supreme Court justices, can't be bought, and that they are serving the public interest and not their own personal interest. In the past, Congress has stepped up to strengthen court ethics. Just last year, we passed the Bipartisan Courthouse Ethics and Transparency Act, which applies the Stock Act reporting and disclosure requirements to federal judges and justices. But the Supreme Court doesn't need to wait on Congress to clean up its act. The justices could take action today if they wanted to, and if the court fails to act, Congress must. In the coming days, the Senate Judiciary Committee will hold a hearing on the need to restore public confidence in the highest court of our land, the Supreme Court. This won't be our first hearing on the topic. We've held a number of important hearings over the years on the need for judicial ethics reform, including an important hearing in the last Congress in our court subcommittee chaired by Senator Whitehouse of Rhode Island. Some on the Republican side may claim that this focus on ethics is just a reaction to decisions being handed down by the right-wing activist majority of the Supreme Court. To them, I say, check the record. I've been at this pursuit for more than 10 years.
Senator Dick Durbin, Democrat from Illinois, chair of the Judiciary Committee, today on the Senate floor. The Senate Republican leader, Mitch McConnell of Kentucky, who's also the minority leader, asked by a reporter today about his view on the ethics issues surrounding Supreme Court Justice Clarence Thomas.
Senator McConnell, do you have any comments on the reports of the hospitality that Justice Clarence Thomas received from Harlan Crow, and the Judiciary Committee's plan to hold hearings on the ethical standards of the Supreme Court?
Yeah, the Supreme Court and the court system is a whole separate part of our Constitution. And the Democrats, it seems to me, spend a lot of time criticizing individual members of the court and going after the court as an institution. For example, my counterpart went over in front of the Supreme Court and called out two of the Supreme Court justices by name and actually threatened them with some kind of reprisal, I don't know what kind, if they ruled the wrong way in a case that he cared about. The Attorney General seemed to be largely unconcerned with security issues around the homes of Supreme Court members. I have total confidence in the Chief Justice of the United States to deal with these court internal issues.
Senate Republican leader Mitch McConnell at a news conference today talking about the plans from the Senate Judiciary Committee Chair Dick Durbin to hold a hearing on Supreme Court ethics. When that hearing happens, we'll cover it, of course, on the C-SPAN networks. From the Kansas City Star, President Joe Biden has invited Ralph Yarl to visit the White House once the Kansas City teen recovers after being shot last week after he rang the wrong doorbell. No parent should have to worry that their kid will be shot after ringing the wrong doorbell. We've got to keep up the fight against gun violence, President Biden said in a tweet Tuesday, and Ralph will see you in the Oval Office once you feel better. President Biden spoke with Ralph Yarl and his family Monday evening as national outrage continues over the shooting. That reporting from the Kansas City Star. More about this from today's White House briefing with the Press Secretary, Karine Jean-Pierre.
I wonder if you can talk about how the president learned about and ingested the news. And a presidential phone call is a significant and rare thing. You know, why did he decide to make this phone call and then to tell the nation that he did it?
So I think also the parent spoke to the phone call as well. I think you guys heard directly from the parents who spoke to the call that the president had with Ralph. And I think you also heard from others who are supporting Ralph in this moment. Look, you guys heard the news. It was a 16-year-old, a sweet kid, as he's being reported, was shot in the head twice. This is a president, as we know, understands loss, understands the importance of making sure that he's a president that's there when a family is suffering and dealing with a hard time. And that's what you saw. This is a president having to deal with another shooting, talking to another family about what they're going through with their kid being shot for ringing the wrong doorbell. Again, I want to be very careful. There's still an investigation going on, so I don't want to get ahead of it. But that's what we know thus far. And so the president wanted to reach out to the family and to Ralph and to say that, we wish him a speedy recovery, have a conversation, let them know that he and the First Lady are with them. And I don't think that's unusual or uncommon for this president to do.
The White House Press Secretary Karine Jean-Pierre taking reporters' questions in the White House briefing room. The 84-year-old man accused of shooting Ralph Yarl, Andrew Lester, has turned himself into authorities and faces felony charges of assault in the first degree and armed criminal action. This is Washington Today. The U.S. House voting today on whether to override President Biden's veto of a bill that would reverse the latest rule governing waters of the United States. Associated Press reports the nation has been waffling over how to define the term waters of the United States in the Clean Water Act since the Obama administration. That rule was reversed and reined in by the Trump administration, which said the federal government is responsible for regulating navigable waters and the rest is for state and local regulation. The newest rule, which took effect March 20th, replaces the Trump-era rule and extends the federal government's jurisdiction. The House floor debate on the veto override attempt of this bill included Congressman Sam Graves, Republican from Missouri, chair of the Transportation and Infrastructure Committee.
I remind my colleagues on both sides of the aisle that since I last spoke on the floor of this chamber in support of HJ Resolution 27, the resolution passed both the House and the Senate with bipartisan support. While the Clean Water Act has greatly improved the health of our nation's waters in the 50 years since it's become law, this administration's rule defining a Waters of the United States, or WOTUS, is just the latest in a stream of examples of executive overreach beyond the intent of the Clean Water Act. Decades of agency interpretations and misinterpretations of WOTUS have created uncertainty, a lot of uncertainty, for rural communities, for farmers, for businesses and industries that rely on clean water. And this rule does absolutely nothing to provide clarity. In his message to the House regarding the veto of this legislation, the President claims that HJ Resolution 27 would, quote, leave Americans without a clear definition of waters of the United States, unquote. This is simply untrue and disingenuous, especially considering it was his own administration that decided to get rid of the 2020 Navigable Waters Protection Rule, which provided long-awaited clarity on the scope of WOTUS in favor of this new overreaching and unclear definition. This issue matters to everyday Americans all over the country, and I hear about it all the time. I'm disappointed to see the President favor radical environmental activists over America's families, small businesses, farmers, builders, and property owners.
Congressman Sam Graves, Republican from Missouri, chairs the Transportation and Infrastructure Committee today on the House floor. Ranking Democrat on the committee, Rick Larson of Washington State, opposes the bill and supported the veto.
This resolution will adversely impact farmers, ranchers, and developers by creating regulatory chaos and eliminating important exclusions that have been codified in this administration's rule to help water-dependent businesses and farmers understand and comply with the law. For example, because it prohibits the EPA from issuing substantially the same rule, this resolution means the elimination of two long-standing exclusions for wastewater treatment systems and prior converted croplands, exclusions that have been relied upon by communities, developers, industry, and farmers for decades. This resolution would also eliminate 6 new regulatory exclusions for features considered, quote, generally non-jurisdictional, end quote, including certain ditches, artificially irrigated areas, and artificial lakes or ponds. Ironically, this resolution will result in more uncertainty and more bodies of water being regulated than under the administration's proposal. You don't have to take my word for it. Just read the Congressional Budget Office report accompanying this resolution. It is right in there. Now, as I mentioned previously on this floor, in another debate on this issue, the Biden proposal, this administration's proposal, will not adversely impact family farmers in this country, period. Why? That's because farmers are, by statute, largely exempt from the Clean Water Act regulation, where less than 1% of all wetland permits relate to ag activities nationwide. Therefore, if a farm is engaged in normal farming, forestry, and ranching activity, that farm is exempt from regulation. The current proposal does not change that exemption. In short, this resolution still makes no sense. It invalidates the current administration's rule and all the clarifications and all the exceptions for business it contains in favor of a similarly structured but much less clear regulatory framework. It increases uncertainty and the likelihood for continued legal battles and gridlock, the opposite of what businesses and farmers are looking for.
Congressman Rick Larsen, Democrat from Washington State, ranking member on the Transportation and Infrastructure Committee on the House floor today. Debate before the vote to override President Biden's veto of a bill that would have reversed the latest regulation on waters of the United States. The final vote in the House was a majority, but short of the 2/3 needed to override a veto, so it will not be heading to the Senate for a vote. The veto stands. As for the regulation, more from the Associated Press article, after a years-long fight between presidential administrations over the Clean Water Act, the on-again, off-again struggle over the Waters of the United States rule is on again and off again, depending upon which state you live in. A federal district judge in North Dakota last week blocked enforcement of the Biden administration's Waters of the U.S. rule in 24 states. That came just weeks after a federal district judge in Texas blocked WOTUS in Texas and Idaho. The Environmental Protection Agency said it would not enforce the new rules for now in the 26 states, using a pre-2015 rule instead to determine whether a body of water is subject to federal jurisdiction under the Clean Water Act. For the rest of the states, the new rule is in effect. Washington Today continues in a moment.
Live Wednesday at 10 a.m. Eastern. The Supreme Court hears oral arguments in a case about whether certain threatening statements on social media are a criminal act or protected free speech. Then at noon Eastern, a Senate hearing about food aid programs, including the SNAP program. Listen live to C-SPAN Radio anywhere on our free app, C-SPAN Now, or ask your smart speaker to play C-SPAN Radio.
Welcome back to Washington Today, available as a podcast wherever you get your podcasts and on the C-SPAN Now mobile app. A few more headlines. Dominion Voting Systems defamation lawsuit against Fox News has been settled. Dominion had been suing for $1.6 billion over Fox News' coverage of the 2020 presidential election and claims of voter fraud. A Dominion attorney says the settlement is for $787 million and represents vindication and accountability. A Fox News statement reads, "We are pleased to have reached a settlement in our dispute with Dominion Voting Systems. We acknowledge the court's rulings, finding certain claims about Dominion to be false. This settlement reflects Fox's continued commitment to the highest journalistic standards. We're hopeful that our decision to resolve the dispute with Dominion amicably, instead of the acrimony of a divisive trial, allows the country to move forward from these issues." And the U.S. Senate Majority Leader Chuck Schumer says he's chosen Senator Ben Cardin, Democrat from Maryland, to replace temporarily Senator Dianne Feinstein, Democrat from California, on the Judiciary Committee while Senator Feinstein recovers from an illness. Her absence has been holding up judicial nominations that Republicans oppose because Democrats do not have enough votes on the committee without her to approve those nominations. But the temporary replacement needs 60 votes in the Senate, and Republicans say they will block that. A tweet today from @IRS News. IRS reminder, file and pay your taxes by the April 18th due date. Need help? Find out how online. The resources can support last-minute filers. It's irs.gov/help. Today is tax day, the deadline for most people to file federal tax returns, unless you have an automatic extension, such as being in a disaster-declared area, or you ask for an extension. Some members of Congress taking the opportunity this day to propose tax reforms. Jimmy Gomez, Democrat from California, introducing the For the 99.5% Act, which would raise taxes on inherited estates over $3.5 million, which he says would apply to 0.5% of Americans.
Welcome to Tax Day, one of the most segregated, most unequal, and one of the most unjust days of the year in America. Not on race, but by wealth and privilege, where we see the difference between the haves and the have-nots, those who are struggling versus those who have exorbitant amounts of wealth, those where a secretary will pay more in taxes than their billionaire boss. That is fundamentally un-American, unfair, and unjust. And that's not because of something inherent in individuals. This was made by decisions of lawmakers over the decades. And the latest was the Trump tax cuts that gave the 60% of all the benefits of their tax cuts to the top 0.1% in this country, making the income inequality even worse. And that is something we know that we can make a difference. That's why Senator Sanders and I have partnered to introduce the 99.5% Act, legislation to ensure that the wealthiest 0.5% of Americans pay their fair share in taxes. The 50 wealthiest individuals in our country right now own more wealth than the poorest half of all Americans combined. And the poorest 40% of Americans have hardly any savings at all and are disproportionately Latinos and African Americans. This is wrong and leading to an erosion of the American dream. This is something that causes people to question, the fundamental nature of America. The idea that if you work hard, you follow the rules, that you will do better than your parents, and then your kids and the next generation will do better than you.
Congressman Jimmy Gomez, Democrat from California, at a news conference today outside the U.S. Capitol building in Washington. His bill would impose a 45% tax rate on estates $3.5 million to $10 million, and then larger tax brackets as the estate gets larger to a maximum 65% tax on estates valued over $1 billion. Some House Republicans also holding a news conference on this federal tax filing deadline day. The Majority Whip Tom Emmer of Minnesota connecting the issues of tax policy to spending policy and to the current debate over whether raising the national debt limit should be tied to spending cuts.
Winston Churchill once said, "I contend that for a nation to try and tax itself into prosperity is like a man standing in a bucket and trying to lift himself up." Joe Biden and the Democrats could learn a thing or two from those words today. Trillions in new spending paired with massive tax hikes on hard-working Americans has been the Democrats' economic mantra over the past 2 years. In just 20 months, their reckless spending policies added $4.8 trillion to the 10-year deficit. Through double-digit inflation and massive tax hikes, they've left the American people, and more importantly, future generations to come, to foot the bill. 2022 tax revenues were the second highest since World War II, and individual income tax revenue exceeded 10% of the GDP for the first time ever. To make matters worse, Biden is now doubling down on his detrimental tax and spend agenda by proposing the biggest tax hike to date, $4.7 trillion in new taxes with his 2024 budget. This includes $1.8 trillion in taxes on small businesses, $37 billion on American energy producers, and $77 billion in new death tax increases, just to name a few. With grocery and gas prices soaring across the country, the last thing that Americans need is more of their hard-earned money coming out of their paychecks for Joe Biden and his tax and spend friends. House Republicans are putting forward a plan that will rein in out-of-control Democrat spending, save taxpayer money, and implement long-lasting reforms to put our nation on a better track for future generations.
Congressman Tom Emmer, Republican from Minnesota, the Majority Whip, at a news conference on the grounds of the U.S. Capitol building with other House Republicans on this tax day. An article at the Washington Times begins Speaker Kevin McCarthy is facing a difficult path toward uniting the House Republican Conference behind a proposal to raise the federal debt ceiling in exchange for slashing spending. With Democrats opposed to any spending cuts, Mr. McCarthy will need every GOP vote to pass the debt ceiling proposal. That may be a tall task because of internal GOP divisions. At least two hardline Republicans, Tim Burchett of Tennessee and Eric Burleson of Missouri, say they oppose raising the debt ceiling. They want Congress to curtail spending commitments. Other members of the conservative House Freedom Caucus are on the fence or want to secure bigger spending cuts within the debt limit proposal. The Speaker also must convince moderate and centrist Republicans to go along with the proposal. That was from the Washington Times. Congressman Matt Gaetz, Republican of Florida, who you might remember led the opposition to Speaker McCarthy's election until the Speaker made certain concessions on how the House operates. Congressman Gaetz speaking to reporters this morning outside the closed meeting of House Republicans where that debt ceiling increase plan was discussed.
Leadership says that they plan to bring this up for a vote as early as next week. Do you think that's a reasonable timeline?
Well, I think a lot of that depends on how these discussions go today, tomorrow, the following day. I'm very interested in the work requirements provisions of the legislation, and so I'm working closely with a cross-section of the Republican conference to make sure that the work requirements are robust, that they drive growth, and that they unify our team.
And a one-year debt limit increase, is that kind of what was discussed in there? When would, if you do agree to raise the debt limit, what would be the deadline?
Well, I don't think that there's any hardening of cement around that as we're having this discussion now. But my suggestion to the team was to have a dollar amount or a date, whichever comes sooner. We're not constrained to just a dollar amount or just a date. We could do either or. And I'm for as many opportunities as we can to have downward pressure on the spending that is driving inflation.
From what you've seen, are you ready to vote for this next week?
Well, I think there are a number of really critical details that we've still got to work out before making a final decision on a vote. But it's been a very productive discussion and a lot of good ideas.
Was there bill text?
Are you hearing text could be released today?
I would be very surprised if final text was released today because there are some of the specifics like the duration and the dollar amount that I think are still left to be decided.
Thank you.
There are some Republicans who are arguing that there needs to be as much as there can in this package, that you need to have the IRS agents revoking funding for them, revoking funding from other things in the IRA. I mean, should this package be as strong as possible? Should it have as much as possible if this is the start of negotiations between Republicans in the White House?
We're $30 trillion in debt. So, yeah, we're for all of the things that can create a downward pressure on spending. And also, we want to use this opportunity to drive some of our policy goals. We're for H.R. 1, unleashing American energy. We're for repealing these 87,000 IRS agents. And so I think that to the extent that we can advocate for broadly popular policy proposals, that's good too. Remember, H.R. 1 was bipartisan when it passed off the House floor. So that's something that I think we're very likely to include in our offer to the Senate.
Congressman Matt Gaetz, Republican from Florida, today with reporters outside that closed House Republican Conference members' meeting. More from the Washington Times article. Apart from imposing work requirements for programs like Medicaid and food stamps, the GOP proposal would raise the debt limit until May 2024. The proposal would also cap non-defense spending and limit future budget growth to 1% annually over the next decade. Republicans have further included provisions rescinding President Biden's student loan forgiveness program, new green energy tax credits, and $90.5 billion in unspent COVID-19 relief. President Biden reacting today.
Yesterday, the Speaker of the House of Representatives, Kevin McCarthy, went to Wall Street. He did not tell the wealthy or the powerful on Wall Street that it was finally time for them to start paying their fair share of taxes. That didn't come up. Other than say they're going to renew the $2 trillion tax cut. Anyway, I won't. Instead, he proposed huge cuts to important programs that millions of Americans count on, million middle-class, suburban, as well as inner-city folks. He threatened to become the first speaker to default on our national debt, which took over 230 years to accumulate. He threatened to be the first one to default on the debt, which would throw us in a gigantic recession and beyond, unless he gets what he wants in the budget. Folks, you've got to ask yourself, what are MAGA Republicans in Congress doing? Because this is not your father's Republican Party. This is a different deal. You know, the two presidents that warned most directly against playing with the national debt were Ronald Reagan. He spoke very, very passionately about that. And he came forward. And anyway, I won't, but you know, why are they doing this? What's the purpose? The Speaker talked about limited spending, which sounds good. And by the way, I was able to cut the deficit by $1.7 billion in 2 years. And if we pass the budget I'm proposing, we'll lower the spending way beyond that just in the first. We're gonna lower the spending by $168 billion just because of the way we've changed Medicare. Prescription drug costs. But let's take a closer look at what he didn't say. Critical programs for hardworking Americans, the ones they count on, will be slashed starting next year if he has his way. He didn't tell you the leading House Republican proposals would cut all the programs and discretionary spending by 22%. It would mean higher costs for child care, higher costs for preschool, higher costs for college. 200,000 children would lose access to Head Start slots. And even more would lose access to child care altogether. It would mean higher costs for housing, especially for older Americans, for veterans, people with disabilities, and families with children. Longer wait times for Social Security and Medicare benefits. Robbing seniors of their healthy meals. 30 million fewer veteran outpatient visits, leaving our brave warriors unable to get checkups, mental health services, and treatment for substance abuse disorders.
President Biden in the White House Rose Garden today during remarks that started on a different subject, affordable child care. He signed an executive order that has more than 50 directives to federal agencies designed to increase access to child care and improve the work life of caregivers. The president said no new money would be involved in that. The initiatives would be funded by existing appropriations. Wall Street today, the Dow down 10, NASDAQ down 4, S&P up 3. A story from TheHill.com. Securities and Exchange Commission Chair Gary Gensler defended his aggressive regulatory agenda from a wave of Republican attacks during Tuesday's House Financial Services Committee hearing. Congressman Patrick McHenry, Republican from North Carolina, the committee's chair, blasted Gary Gensler's SEC for launching more than 50 enforcement actions against crypto companies. He said it's irresponsible for the SEC to sue the firms for failing to register with the SEC when the law is not clear about if certain digital assets are securities or commodities. The Commodities Future Trading Commission has sparred with the SEC over which agency has authority over certain cryptocurrencies. That reporting from The Hill. C-SPAN covered this hearing. Here's an exchange between Congressman McHenry and Chair Gensler about Ethereum, the second largest cryptocurrency after Bitcoin.
How would you categorize Ether then? Look, I think that the general sweep of what Congress did, not just in the 30s, but as amended.
I'm asking you, sitting in your chair now, to make an assessment under the laws as exist. Is Ether a commodity or a security?
Without speaking to any one.
I know you've repeatedly said you're not going to speak to one, except you've spoken to one, Bitcoin. So I'm asking you to speak to a second one, the second largest market cap here.
And speaking to the tokens, there's 10 to 12,000. If there's a group of entrepreneurs in the middle, the public is anticipating a profit based on the...
I'm asking you a specific question, Chair Gensler. I said this in private. This should be no shock to you. I'm asking this question. Is Ether a commodity or a security?
And again, it depends on the facts and the law, and if there's a group of individuals...
I'm asking you about the facts and the law sitting in your seat and the judgment you are making.
And so, Mr. Chair, I think you would not want me to prejudge because I'm also...
But you have prejudged on this. You've taken 50 enforcement actions. We're finding out as we go, as you file suit, as people get Wells notices on what is a security in your view, in your agency's view. I'm asking you a very simple question about the second largest digital asset. What is your view?
And my view is if there's a group of individuals in the middle that the public is
anticipating... All right, so let me just ask a second question then. Do you think it serves the market for an object to be viewed by the commodities regulator as a commodity and the securities regulator to be viewed as a security? Do you think that provides safety and soundness for the product? Do you think it provides consumer protection? Do you think it serves the value of innovation? I think no should be a very simple answer for you here.
I think
that uncertainty is bad, is it not?
And I think that Congress has said that there's one agency, the Securities and Exchange Commission, under this committee.
And you won't answer my question, and you're the head of that agency. So give me a break. Come on.
Congressman Patrick McHenry, Republican from North Carolina, chair of the House Financial Services Committee, questioning the Securities and Exchange Commission chair, Gary Gensler, at today's hearing. It was Gary Gensler's first appearance before this committee in 18 months and the first under now Republican control. Homeland Security Secretary Alejandro Mayorkas giving an update about border security and immigration and what may happen on May 11th when Title 42 ends. That's the COVID-19 Public Health Protection Authority that has been used as a justification to expel migrants that cross the U.S.-Mexico border. Secretary Mayorkas testifying before the Senate Homeland Security and Governmental Affairs Committee, chaired by Senator Gary Peters, Democrat from Michigan.
Mr. Secretary, Title 42 is slated to end in under a month, as you well know, on May 11th of 2023. My question for you is, what changes are you anticipating in terms of the number of migrants arriving at the border after May 11th? And what preparations is the administration making to deal with those individuals seeking asylum?
Mr. Chairman, we do anticipate a surge in the number of encounters at our southern border. Our overarching approach, the overarching approach of this administration, is not only to invest in the countries of origin, given the reasons why people flee their homes, whether it's an authoritarian regime, persecution by reason of an individual's membership in a particular social group, increasing violence, poverty, corruption. What we are doing is building lawful pathways so individuals do not need to place their lives and their life savings in the hands of ruthless smugglers who only seek to exploit them for profit. At the same time, delivering a consequence for those individuals who do not avail themselves of the lawful pathways we provide. And we have exemplified that model in the parole program that we announced on January 5th of this year for individuals from Cuba, Haiti, Nicaragua, and Venezuela. We have indeed seen people avail themselves of the lawful pathway, and we've seen an over 95% drop in the number of encounters at the southern border as a result of those programs. We are surging resources to the border. We are going to be using our immigration authorities under Title 8 of the United States Code, which delivers a consequence for individuals who arrive in between the ports of entry who do not have a lawful basis to remain in the United States. We are working with local communities to increase their reception capacity. We are working with our neighbors, our partners to the south, Mexico and other countries, because we are seeing is not exclusive to the southern border. The level of migration that we are experiencing at the southern border is reflective of the level of migration that is gripping the entire hemisphere.
Homeland Security Secretary Alejandro Mayorkas testifying on Capitol Hill before the Senate Homeland Security and Governmental Affairs Committee, questioned by the chair, Democrat Gary Peters of Michigan. Some Republicans in the Senate and the House have been calling for Secretary Mayorkas to be impeached over his handling of border security and immigration. At today's Senate hearing, Roger Marshall, Republican from Kansas, talking about a resolution he's introducing to express a vote of no confidence in the Secretary.
The Secure Fence Act mandated that the Secretary of DHS, that would be you, achieve operational control of our borders. Mr. Secretary, our borders are not under control. Mr. Secretary, you are derelict in your duties. I would be derelict to not do something about this. And that's why I have a draft resolution here that I intend to introduce in the coming days that would require the Senate to take a vote of no confidence on Secretary Mayorkas. As I've stated on the record before, I stand at the ready to receive articles of impeachment from the House and conduct an impeachment trial in this body. But in the meantime, I think the Senate must show our colleagues in the House that we've had enough of the failures from the Department of Homeland Security and believe that the Secretary is not fit to faithfully carry out the duties of his office. I would like to insert this into the record. Mr. Chairman.
Senator Roger Marshall, Republican from Kansas. You can find today's Homeland Security and Governmental Affairs Committee hearing with the Homeland Security Secretary Alejandro Mayorkas testifying at our website, cspan.org, in its entirety, our video library. From United Press International, Senator Bob Menendez, Democrat from New Jersey, chair of the Foreign Relations Committee, announced a plan for managing immigration to the United States that would rely completely on executive actions by President Joe Biden, including increasing legal pathways, protecting migrants, and punishing human traffickers. Thanks for listening to Washington Today. For more of the stories Washington is talking about sent to your inbox every day, subscribe to C-SPAN's evening newsletter word for word at c-span.org/connect. Have a good night.